Today we're gonna just go over the main parts of the contract. I'm not gonna go through everything because it would take really, really long, but I do want to go over go through the pages and go through the main clauses that do come up and that people get a lot of questions about. And some that you don't get many questions, but in my experience can come up. So I'm just gonna run through them, and if you have any questions as I'm going through it, let me know. If you're watching this video after, if you're watching the recording, any questions, feel free to text me. Anything to you want to make clear. And then if there's anything, also if you're watching the video and you've had any experiences and you're curious, or something I'm not, maybe a clause I'm not bringing up and you want to talk about it, you want to mention it, that it could be very important based on your experience, let me know. All right, so on the first page, in this the beginning of the first page, the only part here, the whole personal property, when it comes to washer and dryer, this part always comes up because it says basically that all personal property excluded on this paragraph is included, like these following items are included. Okay, so essentially they're fixtures. They're usually things that are not personal property. They are fixated to the property. They're attached to the property. So you have refrigerator, dishwasher, ceiling fans, window treatments. You even have thermostats, television wall mounts. You have doorbells, like the Ring doorbells. But very notoriously here, you don't have washer and dryer, and it's happened to so many agents that they don't put washer and dryer here, and then it becomes an issue. So, so if there's any other furniture that's included, you want to put it here. If it's minor stuff, if it's personal, minor, one or two things, you want to include it here. If it's a lot of things, if we're talking a huge house furnished, then you probably want to go ahead and do a separate addendum with a full list of everything that's included. All right. So, and then here in E, I didn't highlight this part to talk about it, but here you would put, if any of these things in this list are not included, you would put them here. Okay. So you want to make sure you do that. Over here, this part's pretty straightforward, guys. This is the very basic part. What's your purchase price? How much is your deposit? Who's going to be the title company holding it? Within how many days is escrow to be made, which we always put 3. This part here, financing, you always want to put how much is being financed. So 95%, 80%, 90%, whatever it is. All right. And then this balance to close automatically will populate when you're doing the deal on Form Simplicity. So the balance to close is basically how much money is still left that they need to bring down. It's essentially their down payment, pretty much, would be the balance. All right, so the next highlighted point is time for acceptance. So typically here on this blank, this is the time for acceptance, meaning your buyer is tied to this offer for this much time. So we're trying to get the seller to make sure they sign within this much time, which we usually put 2 to 3 days after we send the offer. And so basically we want to make sure that we get a response within a timely manner. Now, if this contract is signed after the date here, it doesn't mean that you still can't move forward. If both buyer and seller still want the house, even though maybe it's been a week or however many days, and the seller still hasn't signed, that's okay. We can still move forward. This part here is a little important. I mean, it says the effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed and delivered this offer or final counter. So delivery is important too. That always counts. So if you get a contract signed today, but you don't email it until tomorrow morning, technically the effective date is tomorrow morning. So delivered is also part of that process. So that's very important. It usually happens when it's late at night, client signs really late, you don't send it until the morning. Well, the effective date is the following day. And how does that affect your contract? Well, the effective date counts as day 0. That counts as day 0 in counting days for your inspection period, for your financing period, for things like that. So the effective date is essentially day 0 of the contract. Closing date. So this part, obviously your date is your date, but I do want to talk about closing, and this part comes up when it comes to funding and you being able to get your funding. So the contract, there's another clause in page 8 or 9 that says that when the deal closes, you have to give the keys to the buyer. So then everybody always feels like, well, what does it mean to close? When are you closed technically? So it says here, closing and closing date. The closing of this transaction shall occur when all funds required for closing are received by the closing agent and collected pursuant to Standard S, and all closing documents required to be furnished by each party pursuant to this contract are delivered. So the biggest thing it says there, and my point is, when you're waiting for funding and you're trying to get keys for your client, and the other agent's always going to tell you, no, we got to wait until the seller receives the funds. And that's not the case according to this contract. It says the closings, it has to be received by the closing agent. So the way a transaction in financing works is that on the day of closing, sometimes the day before closing, the bank already wires the money to the title agent. So the title agent already has it, and then it's their job to disperse it. So once they have that money, and once document has been signed, collected, that's when to disperse. Now, usually the way title agents won't disperse until they send that package back to the lender confirms the package is good. But now let's say this all happens late in the day. Let's say it's happening after 4 p.m., 5, 6, 7 p.m. on a Friday, because it always happens to turn out to be on a Friday for some reason. And then all of a sudden the seller's like, well, we can't get keys until my seller gets their money Monday morning. And that's just not the case. The contract here says it pretty straightforward, that closing occurs, we're closed when the closing agent has funds and has received the documents. So whenever they can, you can call the legal hotline and they'll tell you the same thing, that's how it works. You don't have to wait until the seller gets their money, even though that's very common practice in our business, And sometimes I get it, it's not the clients or it's not the realtors, maybe sometimes it's the seller. They feel uncomfortable giving the keys until they get their money. But as long as the title agent can confirm they received it, you shouldn't have any problems. All right. Next clause I want to go over is this automatic extension. So this, it says here that basically you get an automatic 7-day extension if for some reason funds from the buyer's lenders are not available on the closing date due to CFPB requirement. So what that is when it comes to financing, there's something called a closing disclosure that has to be given to a buyer 3 days prior to closing. A lot of times lenders will send that, a week before closing or whatever, just to make sure that they meet that 3-day deadline. So if for some reason your closing date is coming up, let's say, let's say your closing date is today, for example, but the buyer got the CD yesterday and the seller doesn't want to extend, they're giving you a hard time. Well, my buyer automatically gets an extension for up to 7 days. They don't need 7 days, but they can, but they just need the 3 days from the day of the CD. Well, my client already gets an extension because of this. Because even though our closing day was today, they didn't get the CD until yesterday. It is what it is. It wasn't given on time, but you cannot, it's automatically extended. So our closing date is going to be, let's say they got the CD yesterday. You got Friday, Monday, Tuesday. You can close on Tuesday. All right. Occupancy and possession. This is probably another part to keep in mind. Seller has to take everything out of the property. So prior to closing, So seller shall, at closing, deliver occupancy and possession of the property to buyer, free of tenants, occupants, and future tenancies. Also at closing, seller shall have removed all personal items and trash from the property and shall deliver all keys, to the buyer. This came up once, and a client and an agent lost the deal because of this. It was Jennifer. Some of you guys know Jennifer. She lost the deal because the buyer was upset that the buyer probably had buyer's remorse at the end of the day, but the seller, when the day of the walkthrough, right before they were about to go to closing, the seller left a lot of stuff in the property. They left, it wasn't just a few little things like you see sometimes. It was like furniture. They left certain things there. So it was a lot of stuff. It wasn't just, oh, they left a broom and they left a can of paint. No, they left like a lot of stuff. The buyer was already kind of upset for other reasons and went with an attorney and consulted, and this part took them out. This was a breach of contract by the seller. They did not, at the time of closing, have the property free and clear of all personal items and trash, and the buyer was able to back out because it was breach. Seller did not meet, seller was in default, essentially. So that's one way that a seller can back out. So, I mean, a buyer could back out of a contract. So I always tell people, remind your clients, get everything out of there. That's the main job the seller has in a deal, is remove all personal items, remove any trash, only leave, whatever essentials make sense maybe to leave for the buyer, such as, documents about warranties, paint, extra floor tiles or whatever, things like that, as a courtesy, but that's about it. After that, there's this whole section about assignability. That's pretty straightforward. You may assign and be released from liability. You may not assign, or you may assign but still be liable. So that part is pretty straightforward. I did want to get into the financing contingency because this always comes up, and I always like to talk about it. So I have this part in yellow, and then you're gonna read the blue part too. So this hasn't changed much, but it did change recently, and it does come back to that whole appraisal contingency. Do I need to do an appraisal contingency? Okay. And if you read the yellow part, it's the very straightforward verbiage we've always had. This contract is contingent upon buyer obtaining loan approval. Okay. But if you read the blue, okay, it says, and buyer's mortgage broker or lender having received an appraisal or an alternative valuation of the property satisfactory to the lender, if either is required by lender, which is sufficient to meet the terms required for lender to provide financing for buyer and proceed to closing. So this essentially is saying that you have to have a satisfactory, this is what ties that loan approval with the appraisal together. And it's essentially saying that you have to have it. Now, if you still want to do an appraisal contingency, just to be, sure, I still would recommend it. And we send it all the time. But if for whatever reason the seller is being, want to do an appraisal contingency, stuff like that, you can still get away with just doing this clause. And if it doesn't appraise, then you can get a letter from the denial lender saying, hey, this appraisal is not satisfactory based on the terms of the loan application. Okay. So you can still kind of get away with that. Now, I still, just to be clear, just to be transparent, and there's other parts of the contract where I'm going to tell you like, hey, just do this just to be super, super clear and not leave anything very vague. And this is one of them. I would still always recommend send that appraisal contingency. But this whole section, you're typically good with just this. Even here, this other part that are highlighted here, it tells you that buyer shall make application for financing. Oh, sorry, 1 second. I gotta move something out of the way. Buyer shall make application for financing and use good faith and diligent effort to obtain approval of a loan meeting the financing and appraisal terms of the above mentioned paragraph, which is this paragraph right above it, within the loan approval period. So again, the appraisal, it's saying, you know, you have to make good faith to get the loan approval, meeting the financing and appraisal terms. All right. Another thing here, line 106. This comes up sometimes because buyers are always asking, like, well, how much information do I need to give the seller about what's going on? Well, it tells you right here. Buyer shall, upon written request, keep seller and broker fully informed about the status of buyer's mortgage loan application, loan processing, appraisal, and loan approval, including any property-related conditions of loan approval. Buyer also authorizes the buyer's mortgage broker, lender, and closing agent to disclose such status and progress and release preliminary and finally executed closing disclosures and settlement statements as appropriate and allowed to the seller and broker. So the lender and the title agent can provide updates, can provide status updates. The one thing that comes up sometimes is like, well, can they get a copy of the appraisal? No, they can't. They don't, unless the buyer approves it, unless the buyer says that's okay. But generally speaking, you don't have to provide a copy of the appraisal. Okay. So that's kind of what that section kind of lets you know. So absolutely, seller, both title agents. So sometimes you might, you know, it's happened where they're like, well, the title agent gave an update about what's going on with my mortgage to the seller or the seller's realtor. Well, yeah, they're okay. This contract says that you're authorizing them to do that. All right, and then I didn't highlight this section, but I want to point out section 3, section 4, section 5, section 6. These are all tied to the financing contingency. And it tells you basically each one of these sections walks you through what happens if buyer gets loan approval but doesn't close, or what happens if buyer doesn't get loan approval and doesn't close. Okay, so these are all great things to know. The main one to know, okay, is the 6th one, which is like what happens if buyer does get loan approval but doesn't close. All right, and if you read it, it says if buyer has timely provided either written notice like above that they did get loan approval, but therefore after fails to close on the contract, the deposit is paid to the seller unless failure to close is seller's default or inability to satisfy contingencies, or property-related conditions of the loan approval, excluding appraisal issues. Okay, so let's say it's an insurance issue, like, oh, well, buyer, the buyer it says there on the loan approval, buyer's approved. However, it's also, we have not received the insurance yet, so buyer must get insurance on the property. And let's say for whatever reason, the property cannot be insured. That is a property-related condition of the loan approval. So if buyer gets loan approval but fails to close for something like that, then that's okay. The buyer would get their deposit. Okay. So it's very important to know that. All right. Now the key to having this process, and what I always remind everybody, so then you might wonder, like, okay, Vic, so what you're saying is that if I fail the appraisal, then the seller keeps my deposit. But this is what you have to keep in mind. Like, because in this scenario of paragraph 6, you've given written notice that you got loan approval. The way to do it now, and this started about 2 years ago, is your loan approval and your appraisal, you need to have them together at the same time. You should not be showing your loan approval by itself without getting your appraisal yet. So they have to be at the same time, okay? They're pretty much essentially like tied together. But if you give a seller a loan approval and you still have not gotten your appraisal, that could be an issue, because then you've said, okay, my loan's approved, I'm good to go. But then later you get an appraisal that went bad. That's not good. And that happened during the change for this was when the market was 2021, 2022, when prices were jumping up, and you know, you were seeing a lot of properties not appraising and deals falling apart because people were just overshooting and, you know, offering 50, 60,000 above asking price. So that's when they said, no, from now on, appraisal and loan and loan approval have to come at the same time. So that's the way to do it. Okay. And this is this part of the contract. We're gonna go over more things, but this is one of the most important sections, like understanding these sections. You know, it does say here that you're able to cancel if buyer is unable to obtain loan approval within the time period that they put, which by default is 30 days. They can provide written notice as long as it's on the 30th day or before. They can provide written notice that they have been unable to obtain loan approval and get their deposit back. Okay, so that's also pretty clear. It also says here, if you don't say anything, okay, this is actually very, very important. Can back out within 3 days of the loan approval period expiring. So that's very interesting. So I remember we had an issue where a seller wanted to back out of the contract intentionally. And one of the ways we knew that we could back out was if they don't say anything about their loan approval period, if that date passes, the next day you can put this clause into effect and say, hey, the time period expired for loan approval. You did not let me know that if you did not provide notice that you got your loan approval, so I'm going to use this clause to opt out of the contract. So that was a situation where a seller wanted to not sell anymore. It was just basically a family situation. Like they were selling out of necessity. One of the family members eventually said, hey, don't worry, I'm going to take care of you. Oh, but but I'm already under contract. I have no choice. So we were looking at ways to back out of the contract, and that was one of the ways. So that's very important, guys, to just know all these read all this and understand it very well. They have done an at making it more clear, because I remember like when I first started real estate, this whole section was super unclear and there was a lot of vagueness in it. But now they pretty much laid out all the scenarios and what happens if loan approval is received and it doesn't close, and who gets the deposit in that situation. All right. All right. So another next section, closing costs, fees, and charges. I'm not going to go too much into this. I just wanted to highlight that the contract does lay out what is paid by seller and what is paid by buyer. So you could always look to see what is paid, and then based on what we check on the next page, they might pay this if certain boxes are checked. Okay, so but it pretty much lays it out. After that, this whole section about title insurance, title evidence, all it says for the most part is that you have to have your title commitment within 15 days. So a title agent has to provide the title commitment within 15 days, showing that, you know, title's clear and all that stuff and everything is good. It also mentions that if the previous owner has their title policy, they can provide it to the title agent, even though that's not very common practice, but they can do that as well. And basically what that does is that it helps with the title agent's job, and it helps with the title insurance policy having the prior policy, and it also can save them some money. So yeah, but a lot of people don't do that. All right, so in the next page, we have these three. I highlighted them in blue, red, yellow, just to differentiate. So you have three options. Seller shall designate closing agent and pay for owner's policy. Buyer shall designate closing agent and pay for owner's policy, and charges and premiums, and lender's title policy and endorsements. Or the Miami-Dade Broward regional provision. So in this one, the buyer shall designate the agent, the closing agent, but then the seller is gonna pay for the search and title search. And then it says down here that the seller shall not pay more than $200 for that lien search. All right. So one thing we learned last year, when I think it was last year, I don't remember if it was last year already, the year before. Yeah, I think it was last year. We did this training with Claudia, and we went really deep into the contract. And we learned that you don't have to necessarily be in Broward or Dade. You know, the property doesn't have to be in Broward or Dade to use this provision. It just happens to be called the Miami-Dade Broward Regional Provision. But the contract says nothing that you have to do that in the Broward. However, you know, in the Tri-County area, it's very common that buyer to use this provision, or in Broward and Dade. But pretty much everywhere else, it's very common that seller shall designate. So if you're doing deals in Orlando, Tampa, Jacksonville, you see a lot of times they want the seller to designate the closing. It's just how they're used to working. Just like here in Miami-Dade, Broward, sometimes in West Palm, and even in Fort Myers, Lehigh, you see a lot of this Miami-Dade Broward regional provision being used as well, and buyer choosing. So yeah. All right. Next, special assessment. So this, I just want to always remind you that when it comes to special assessments here, it is specifically talking about city or county special assessments, which are pretty rare. You don't run into those very often. And it just tells you if there are any of these special assessments, seller shall pay. It gives you two options. Option A, seller shall pay installments due prior to closing, and buyer pays the installments due after. B, seller pays it in full prior to closing. And then it says, if there's an assessment where the county or the city does not allow prepayment, then option A is the one that you're going to go with. It also mentions that this doesn't apply to special benefit tax lien imposed by a community development district. So CDDs, essentially, that doesn't apply to that. Okay, that doesn't apply. This section doesn't apply. It basically applies to special assessments by the city or county if they're doing improvements in your neighborhood and they are charging you, they are adding something to your taxes or something like that, to pay some of that cost. All right. Next, guys, disclosures. So here, this is the section. You have a lot of general disclosures that you are there for the buyer to read and know, and the seller as well. Some of these are just like automatic instead of having separate addendums for these. Some of these are mandated by it's a federal law or it's a state law, so you know they just put them in here. One thing here to remember, I mean, this has come up, that's why I mention it, even though it's very, very rare. But the buyer, if they're unable to get flood insurance, meaning the property, for whatever reason, does not qualify, so it's ineligible for flood insurance coverage, the buyer can back out of the contract and get their deposit back as long as these findings are found within 20 days. So that's actually happened to a property. I forgot the reason why it was ineligible for flood insurance. It might have been because for whatever reason, it was maybe to the elevation of the house was maybe below what it should have been elevated. But it did come up once where the property was ineligible for the flood elevation. Luckily, that was found within the 20 days. And we didn't have any issues, and buyer was able to get their deposit back. All right. Here's one that a lot of people don't read that I would pay attention to in this. All right. This is the property tax disclosure summary, and it's very big letters for buyers to read. And we know that buyers don't read this, but this is good for you guys to know, realtors too, because this is here. Because clients come back to you about this the year after you close. It says buyers should not rely on the seller's current property taxes as the amount of property taxes that the buyer may be obligated to pay in the year subsequent to purchase. A change of ownership or property improvements trigger reassessments of the property that could result in higher property taxes. If you have any questions concerning valuation, contact your county property appraiser's office for information. So it's telling you, the contract tells the buyer, hey, what you're gonna pay in taxes is not the same as what the current seller has. You know, it's gonna go up, and it does, and it always goes up. Now, this should always be part of something you talk with your clients. This is part of educating them on you know, home ownership and how it works to buy a house. But if by any chance they come back to you saying, well, you never told me this, you never said this, it's on the contract. Okay, so this is a very, very good thing to know in case a client ever comes back to you. And usually when they come back, hey, it is what it is, you have the conversation. But if they come back to you trying to, like, say you failed them legally or something like that, then, you know, you could refer them to this. Here you have a seller's disclosure here. Now, you should do an actual seller's disclosure, but here it gives you like a little small vague one that just says that seller has no knowledge of, you know, seller has no knowledge of any issues unless mentioned in a separate seller's disclosure. So, you know, this part is here. Moving on to property maintenance, condition, inspection, and examinations. I like to, this first sentence here is pretty good. And guys, I'm gonna go over something here that sometimes people don't know in this inspection section. Except for ordinary wear and tear and casualty loss, sellers shall maintain the property, including but not limited to lawn, shrubbery, and pool in the condition existing as of effective date. This has come up a few times with grass and with pool. You know, seller shows up for the inspection, or they show up for the final walkthrough, and the pool is green, the grass hasn't been cut. It is the seller's responsibility to maintain those things all the way through the closing. So a lot of times, unfortunately, it does, you know, at that point the buyer just closes and deals with it. But can the buyer technically, well, let's say you have a disgruntled buyer and he's like, you know what, it's just a matter of principle. You know, this guy just left the pool like this, left the grass like this. I don't want to close. And then they go talk to an attorney, and then they see this line, and it could be, well, that may be a breach of contract by the seller because they did not maintain the pool or the grass. They let the pool go be dirty. They let the grass grow, whatever it may be. Okay. So it's one thing to keep in mind. Moving on, guys, this is, again, one of the very most important property inspection and right to cancel. This is one of the most important clauses in the contract, apart from the financing contingency. It does say if buyer determines in buyer's sole discretion that the property is not acceptable to the buyer may terminate this contract by delivering written notice. So this is at their sole discretion for whatever reason, no explanation needed, no inspection required. They can back out. Okay. I do want to mention this bottom paragraph here that a lot of people sometimes don't get to read. Okay. It says, unless buyer exercises the right to terminate, okay, unless they exercise the right to terminate, buyer accepts physical condition of the property and any violations, code violations, government violations, environmental violations, any violations, the buyer is accepts that those conditions, but it's still subject to the seller continuing the maintenance requirement. Okay, and buyer shall be responsible for any and all repairs and improvements required by buyer's lender. So what does that all mean? Number one, buyer moves on from this, they're taking the property with code violations. It's on them. Okay, any type of code violation, it's on the buyer, unless the seller fails to do something and then all of a sudden it causes a violation. So meaning, I don't know, just, you know, a simple one is like they don't cut the grass. the city goes and says, okay, we're putting a violation here because the seller didn't cut the grass. Well, in that case, that's different. They didn't cut the grass, so they didn't keep up the maintenance of the property. So then that's not on the buyer. All right. And then the last sentence is very important, little hidden one that sometimes comes up. Buyer shall be responsible for any and all repairs required by buyer's lender. So what is required by buyer's lender? Typically on the appraisal. So if the appraisal comes back saying the bars on the windows need to be removed, there needs to be a specific fire smoke detector, or there's a bathroom that it's required, it's required to have a window, or it's required to have a vent. Those things are not on the seller. Those things are not on the seller. And I know sometimes we try to get the seller to cover those things, but they're not. You know, you can always negotiate it. Of course, you can negotiate it. But if you're on the seller side, you just say, well, you know, that's on you. The contract says that you're responsible for that. And if the buyer doesn't like it and buyer's like, well, I don't like that. You know what? I don't want to do this contract anymore. Okay, great. I'm going to keep your deposit, you know? Now, ideally, you know, obviously our goal is to get the deal to close. So if we have to negotiate, we will. But don't feel like it's automatically on the seller. It isn't. By default, it's on the buyer. So, you know, my first thing in this situation is like, oh, yeah, all right, well, buyer has to pay for those things. So just keep that in mind, you know. But obviously, if it's a major expense, all of a sudden, oh, well, if the buyer pays for these things, they might not have money for closing. Who knows? Whatever the situation is, then obviously it's in everybody's best interest to just try to negotiate and probably maybe have the seller do a contribution. All right. Walkthrough inspection, you know, just to point out, it just makes this very clear. On the day prior to closing or on the day of closing, buyer has the right to do a final walkthrough of the property, just to confirm that all items have been removed and that the property has been maintained. Okay. So that's essentially the purpose of the walkthrough, you know, just to make sure everything's been removed and to verify that the seller has maintained the property as required by the maintenance requirement. All right. Next section, I highlighted this: seller assistance and cooperation in closeout of building permits. So, you know, normally in our contracts, we put that clause in the additional terms that seller's going to get rid of any building permit issues. But if we don't put that, it's on the buyer, like we just spoke about during the inspection period. If that's the case, the seller does have to cooperate, because obviously if you're trying to clear building permits, you don't own the house yet. So there's going to have to be people going there. The owner themselves are probably going to have to sign paperwork. The owner themselves might have to go to the city. Who knows? Whatever it may be. So they have to cooperate, you know, with that process. You know, that's all this section pretty much is saying. All right. All right. Shifting to escrow agent and broker. Let's see what I highlighted here. This is just, you know, just for us realtors as to protect us. It basically says here, buyer agrees to rely solely on seller, professional inspectors, and governmental agencies for verification of property conditions, square footage, and facts that materially affect the property value, and not the representations, oral, written, or otherwise, of the broker. So it pretty much like takes all the liability from us, like, you know, whatever it is, no matter what, like, you know, a seller can maybe still come sue you after the fact, but this contract that they signed says that, hey, you were not to rely on the broker for the square footage or for these things that affect the property. No, you were to rely on the seller. That's why you do a seller's disclosure. You rely on your inspector, and you rely on whatever the government, the city, the county. You know, if the city didn't have the violation there, a lien search was done, there was no violation. All of a sudden, after the fact, the violation shows up. well, they failed you. Okay, it's not on the broker. Okay, none of the details, none of that stuff is so even if we do it written or orally, it doesn't matter. Like, that's not on us. So obviously we do our best job to inform the client to the best of our ability, and that's what we do, and that's what we should do. But the contract does let them know that they should look for inspect. We're not home inspectors. We're not the seller. We like they're the ones that lived in the property. And we're not the city or the county. So that's who really they should verify everything with. Default and dispute resolution. So pretty much, I mean, what I put here is a few things. If buyer fails, neglects, or refuses to perform buyer's obligation on this contract, including payment of deposit, seller may elect to recover and retain the deposit for the account of seller as agreed upon liquidated damages. Pretty much, for the most part, what you need to know is that if the buyer defaults, the seller's main recourse is the deposit. Like, that's it. And going after the deposit, a seller may try to sue for more damages, but generally speaking, that deposit is what you're agreeing that that's it. Okay. If the seller defaults, so what is the buyer's recourse? Let's say the seller fails, neglects, or refuses to perform seller's obligations under this contract. Well, in that case, buyer may elect to receive the return of their deposit. And as you see here at the bottom, it says may seek to recover such damages or seek what is called specific performance. So when a buyer defaults, seller gets the deposit. That's their main thing. When a seller defaults, the buyer gets their deposit back. They can do that, and they can sue for damages and specific performance. Specific performance is exactly kind of what it sounds like. I want you to specifically perform what you said you were going to do in this contract, which is sell me the house. You know, so they can try to get a judgment and a ruling for the seller to sell the house. I've had people ask me, can that really happen? Yeah, it really can. So, you know, a lot of times people will settle and they'll do things like that, but you really can seek for that, you know? All right. After this, there's a section here starting on page 7 that just talks standards for real estate transactions. It's a great read, and it just kind of tells you how things should work. You know, it just tells you generally how situations, how they should work. So there's a lot of these. I highlighted this one here about title examination because I think it comes up. So this is in regarding to title commitment and issues in title, because people always wonder, well, what comes up? What happens in the situation when there are issues in the title commitment? Who takes care of it? The buyer, the seller? So by default, this is how it works. Okay. Buyer, if there's title issues, buyer shall have 5 days after getting the title commitment to notify the seller in writing of defects and any issues that make the title unmarketable, or basically you don't have what is called clear title. All right. Then what happens after that? All right. So then the seller shall have 30 days, which we call the cure period, after receiving that notice to take reasonable, diligent efforts to remove the defects. If buyer fails to notify the seller about this, then what do you think? Buyer shall be deemed to have accepted title as is. So you have to let them know within 5 days, which in general, people let you know right away, immediately, the same day. Okay. This is why it's important to follow up with your title commitment. Your title agent should be giving this to you, but if you're not getting that in 15 days, you need to like hit them up. Be like, hey, where's my title commitment? So you can't back out. Sometimes people think, oh, buyer can back out because of this. No, you can't back out. You have to give the seller the 30 days for the cure period. All right. Then after this, it says here, if seller is unable to cure defects within the cure period. So let's say you give them the 30 days, they're not able to cure it. You have option A, B, and C. You have 3 options. You can extend that cure period for 120 days. You can decide to just buy the property as is, or third option, buyer can back out. So that's how that works. That's how it works when there's titles and defects that the seller has to correct. First, they automatically get 30 days. And if you still need more time after the 30 days, buyer can elect to give them another 120 days. Buyer can elect to say, you know what, I'm just going to take the property how it is. Or buyer can elect to say, I'm just going to back out of the property and get my deposit back. They would get their deposit back in that situation. A lot, you know, it's never come up for me personally. But if you give them the 120 days and they still don't close, then you can, then the options are the same. You can give them another 120 days, you can accept it how it is, or you can cancel and get your deposit back. All right. Lease information. Seller shall, at least 10 days prior to closing, furnish to buyer estoppel letters from tenants, occupants specifying nature and duration of occupancy, rental rates, advanced rents, and security deposits paid by tenant. So this is in a situation if your client is buying a property and it's currently being rented, they have to give you 10 days prior to closing all the details of that lease agreement, okay? They have to let you know how much the tenant is paying, how much money in deposits, how much time they're going to be there for, which will all basically also will sign it, and that's how you confirm that it's good. All right. Very simple one. Time is of the essence. Calendar days are used to count days on this contract. And this is also where it says that if any deadline of this contract lands on a Saturday, Sunday, or national holiday, and that deadline automatically gets extended to the next business day. So if you accidentally put your closing day for a Saturday or a Sunday, you're like, oh, I need to do an addendum to make that. You don't have to make an addendum. The contract already says it automatically gets extended until Monday. All right. So use that to your advantage sometimes. Like I'll know when I'm sending an offer and I'm like, oh, I'm putting, you know, let's say the seller's being pushy on inspection days. And I put 7, but they're telling me, no, we want 3. And I'm like, okay, but today's Wednesday. So as long as if we sign today, I'll have Thursday, Friday, Saturday. And because my 3 days ends on Saturday, I'll have technically until Monday in my inspection period. So that happens sometimes, and keep that in mind because it's good to know that for you guys, because sometimes you do get a little squeezed on the inspection period from a seller. You want to get 7 days, you want to get 10 days, but then they want to squeeze you down to 5 days, 4 days, 3 days. But as long as that final day ends on a Saturday or a Sunday, you get that extra 1 or 2 days. And if there's a holiday on a Monday, then you get potentially 3 extra days. So keep that in mind, okay? I didn't highlight force majeure. Oh, I did highlight force majeure here. Force majeure, guys, is basically when services shut down due to hurricane, terrorist attacks, floods, pandemics like COVID. And then, so it basically, you know, this is a part of the contract that when these things happen, we know a hurricane's coming and stuff like that. We tend to look at it a little more. But basically, all it says is that if services such as a title company or a lender, a bank, are closed due to the fact that there's a hurricane or something that's causing, you know, just services and businesses to close down temporarily, that it'll be extended for a reasonable time up to 7 days after whatever pandemic or hurricane no longer prevents businesses from closing. So so you have time basically. All right. So basically, now can the buyer back out of this? Only, okay, when whatever pandemic or force majeure issue causes services to close beyond 30 days. So whatever services, if for whatever reason it's going past 30 days, at that point the contract says, you know, either party can elect to terminate. All right. But by default, a hurricane comes, title company and lender have to close down for a week. You gotta wait until they open back up, and then you automatically have 7 days after that. Even if your closing date passed, you still got 7 days to close after that, after they're open. All right. And again, guys, there's a lot more things here, but they just don't come up. Like, these are things that just don't come up. Very, very, very rare. That doesn't mean that they can't. And, you know, as we continue to grow in this business and we continue to go through more things, it's possible in the future, I might go over a few more of these things, but the rest of it is things that are very rare and things that, you know, I wouldn't put the time to go over in this training. The final thing, guys, I'll leave you with is, remember these addendums. These are all addendums that are part of the contract. So think of this contract as going over all the standard things that it should go over. However, there's a lot more scenarios and a lot more situations that can happen. So what the state does is they break it up into addendums. So some of these addendums could be part of your contract. So for example, the condo rider, the homeowners association disclosure, things like this could ultimately be part of your contract. So very common ones: condo rider, homeowners association, the appraisal contingency, lead-based paint disclosure, any property built prior to 1978, you still have to do that. Housing for older persons, so if you're doing a deal, Century Village or a 55 and over community, you would put that. Backup contract, we recently had to use that one, so that one comes up sometimes. So there's a lot of other licensee property interests. So if you're buying a property for yourself or selling a property of your own, you have to do this addendum disclosing that you're an agent. So these addendums are all based on different scenarios. So it's good to read them and know what they are. But like I said, the ones I just went over are the most common ones. And then here in your additional terms, this is where, if you guys have done a training before and I taught you how to do the contract, I'll always teach you, put here that the seller agrees that they will sell the property to you free and clear of any liens, code violation, and open or expired permits, and that seller will close those at their own expense, even if found during the inspection period. Like no matter what, like even if these things are found during the inspection period, because the inspection says that you have 7 days to do that, and then beyond that, you are accepting the property with code violations. So by putting that part, that it doesn't matter if it's found during the inspection period, it covers you. So if you go to Form Simplicity, at the top it says insert clause. Okay, and everybody has this on their Form Simplicity. It says insert clause, and just put the clear title clause, and it'll automatically write the clause for you there. Okay. And Priscilla, what you write here: if you check off an addendum and do not send it with your contract, the contract is not considered executed. Absolutely. All documents need to be signed by all parties and delivered, including compensation agreements. Really, really good. So your contract is not considered executed if your addendums are not. So if you check one of these addendums, but for some reason the addendum doesn't get signed, you're not under contract. So how does this come up sometimes? Well, sometimes you'll do a contract, but maybe you forget an addendum, or for whatever reason the addendum doesn't get signed, but you get your contract back. And then let's say you get the addendum the day after. You finally figured out, oh, we made a mistake. We're gonna get the addendum, get it done. You get it back a day after you got your main contract. Well, in that case, the day after, the day when you get that addendum, that now becomes your effective date. And sometimes agents are unaware of this and they'll argue on this. They'll say, no, you have to put the deposit within 3 days. You're short a day. No, we're not effective until the addendum is also fully signed. So yeah, great point, Priscilla. I appreciate that input. So that's it, guys. Like, I really wanted to do this refresher. I feel like, you know, we have you know, I like to do this probably once, twice a year, like to go over it, like to remind everybody, and we're always learning something new. Because when issues come up and a buyer and seller are having a disagreement, we try to go back to this contract and figure out, like, okay, where does it say what we do in this situation? And a lot of the stuff I went through with you today is mostly based on all the experiences we've had over hundreds of transactions, probably over 1,000 transactions. And you know, just the issues we've had for all these years. So so the biggest thing I would recommend too is just always understand the financing contingency, especially these parts right here in the back where it tells you the ifs. So if you notice, they all say if this, if that, if this, if that. So understand this, because it tells you, like, if within the loan approval, buyer gets loan approval, this is what happens if you don't close. But if he does get loan approval but doesn't say he got loan approval, this is what happens if you don't close, and so forth and so forth. So definitely read these, and it'll help you better, you know, just understand and manage your client. And I feel like the more you know the contract, the more educated you are, the advantage you'll have in dealing with these situations over the other agent, and the better you can represent your client. So that's it, guys. That's all I got for you today. I'm gonna post this recording. I'll probably put it in the chat later this afternoon. So in any case, you can go back to it and go through any sections I went through. And as always, if you have any questions, anything at all, feel free to reach out. And we'll go over and we can go more into detail and break it down. Oh, here's another pro tip, guys, before I let you go. If you're ever curious about one of these clauses means, and this is kind of new, but it's pretty cool, copy paste it into ChatGPT and be like, can you explain this to me in plain English? And tell ChatGPT to do that for you. And it does a good job explaining, like, oh, well, this is what this means. So it's pretty cool. So you can actually have it break it down for you. And like, you could ask it questions too. You could ask it, like, you could copy paste a thing, or you could just put the whole contract and just be like, you know, in this contract, section H or line 236 mentions this. How does this work? And then you could even tell it your scenario. Now, do I recommend going on ChatGPT and you know, like, going by that? Probably not. It's probably, you know, you don't want to get in trouble going by ChatGPT's advice. But in the times I've tested it, it has reaffirmed my knowledge of it. So it's pretty cool. So it works really well. All right, guys. So I'm gonna leave you guys with that. Let's keep it moving. Let's keep it pushing. Let's hopefully write some more contracts. You know, just starting off this second quarter. And so hopefully you guys will be looking at more of these contracts and writing more offers soon. All right, guys. Juju, I appreciate it. Munir, Priscilla, Danielle, Eddie, good to see you. I'll see you guys.
Thank you.
Thanks, Vic.
You guys on the next one. All right,
Appreciate you, fam.
Thank
Yeah.
you. Bye.
Bye, guys.